The covenants are just formalizing a relationship between property owners that already exists as a matter of common. There's no such thing as a free ride. The Cohens and the Arnolds would have had to pay for this maintenance regardless of the covenants because it's common infrastructure. Their house would flood without that stormwater management system.
So let me ask you two questions, Frank. And the first one is, you mentioned no insurance coverage. So if they were, and I don't see it happening, but if they were to well, if the case were to settle, or if the case were to go to court, and there would be a judgment against the board or the association, who would have to pay that? Would it be the members, or who would have to pay that?
Yes, the members would. 720 even talks about carving out basically like a offset to assessments. When someone suit and prevails in the litigation, they get an offset. Whatever expenses the association spent on the lawsuit, that homeowner is basically exempted from that. So the statute contemplates it, but the bottom line is the homeowners will pay for it.
And I guess that would apply to any claims that the association might bring against. Well, no, it wouldn't. They could be personally liable here for claims brought against them. Yeah.
And not just that, but many of my claims are under the declaration, Judge. So I believe I'm going to be able to get my legal fees.
And Judge, one of the reasons we don't want to use the insurance company is it's the position of this community that we wish to countersue, or just go ahead and bring our own personal lawsuit against them to stop this. So in order to do that, we can utilize, and that's what they're stating during the past meeting, is that, well, you can just file it with your insurance. They're looking to be monetarily compensated from their neighbors rather than working it out with them.
Well, that was my next question, Tamika, and that is, how long are you going to put up with this? And you know, are you going to just wait to be sued? And I know this is a question that you have to decide, you know, and maybe have decided with your attorney, but you know, you have as much right to sue them as they have to sue you. And whether you would need, you know, a membership vote on that, I don't know. And those are all other things, but it just seems like, you know, you aren't in a position where you just have to sit back and be defamed and be attacked and be have your property values devalued by what they're doing. And so,
correct.
You know, I had said before that I had assumed that it would be these two families that would initiate litigation, but maybe not. And so, Frank, I think you want me to let them know how strongly you are going to defend and counterclaim back. And I've done that because of what I've read from what you've done, written, and I'm going to do that again, but I'm going to add to that two things. And one is that there is no insurance coverage here, and so that any monies that they might recover in this lawsuit would be the responsibility of the members of this association. And the other is that forgot what the other one was right now, but I had asked them to do two things, and I kind of wish I hadn't done it this way, because I see you as I kind of envision this as the association, or as the HOA as being a defendant in the lawsuit. I think you're as much of a claimant in the case, or as a defendant, or much of a counterplaintiff. But I'd asked them to. And I think it's still going to be valuable to do, because it'll be interesting to see what they think. And I said for them to think where they would like to start in this mediation, either monetarily or on the non-monetary claims that they would make. I don't know if you have any idea what they would like non-monetarily, but it goes into everything from apologies to removal of every board member and all kinds of things. But
which we have absolutely no ability to do that, and you only remove board members by recall. Literally, the homeowners have to vote on it.
Well, I'm sure. I think once Jim got going on it, he didn't know where to stop on everything, because the monetary in this is in the hundreds of thousands, if not more, dollars, which you know, including or not including attorney's fees in the case. But I had asked them to, while I was meeting with you, to think of where they would like to start in this mediation. Tamika, I think that this mediation is going to go nowhere at all. They're going to make, whether they, I don't know if I said it to you or to them, but whether they demand 500,000 or whether they demand 5,000, it's not going to settle. This case is not going to settle, and there's just, it's going to.
Unfortunately, Judge, I think it's going to be where they just won't stop until they're forced to stop. It's just harassment.
Yeah, but I can certainly, the other thing, and I don't know what you would think of this, Frank, but I had suggested to them to consider a alternative dispute resolution through arbitration, and I don't know if that, I don't know that I would think that would be better. I was thinking when I was talking with him that it may be, because it would be cheaper, faster, and final, and I could expand on that, but and those are things, and especially on a streamlined type situation, both sides come in and tell your story. Maybe 1 or 2 depositions, no document requests, and just a production of documents that each side would use at a final hearing. Yeah, and I don't know that would be the best way for you to proceed. To me, these although I can tell you as a person who does almost all arbitrations, that these signs are as effective on me as they would be if I were a judge or a juror. And, the other misconduct that I've been hearing about today, which I had not, I've read a little bit about, but now I see some of it, could be as effective in arbitration in your favor as it could be in a court of law. But so I'm going to leave that one aside. I'm not going to talk further with them about that. I'm not suggesting myself as the arbitrator. I couldn't be the arbitrator. James, of course, could be, but I'm not even pushing that. I'm just thinking maybe if you wanted a quicker resolution, that could do it. But I don't know that it's the best way for you to go. So I'm not going to, we don't have to talk about that. But
look, I'll talk to the board about it. My thought, to be honest with you, Judge, is I want a jury. I want a jury to see this.
Yeah.
I want jurors to see this because they're going to understand, I think, and they're going to see through this. And I think that they're going to be more inclined to maybe be more penal at the end of the day.
Yeah.
Judge, my number one question, I guess, if I accomplish one thing today for my client, I want to understand, if I can, if possible, what Mr. Walter's mindset is.
And that's why I think you could have your own conversation with him. There's nothing prohibiting that. And are you asking what his reaction would be to this if he doesn't know it? Is that what you're asking, Frank?
I'm fairly certain.
I honestly want to understand, I guess, judges, from an attorney, where do you really think that your case is? Where do you really think that you have facts and the law in your favor? Because if I look at this as an attorney from their perspective, I don't understand why he would even consider getting involved in this.
Frank, I honestly don't think that they've conveyed to their attorney all of the documentation that we have against them. He's probably hearing one side of the story.
Well, he is. I think he is. I mean, at least that's the only side he's told me.
Right.
But that's where I think, probably a joint session today wouldn't accomplish that. But I do think a private conversation with him, where you maybe even get together and or you can do it like we're doing today and just say, to convey this to him. And the other thing that might be advantageous here, it would be for you to consider yourself as the plaintiff in the case and what demand you would make in arbitration or in mediation, rather than being on the defensive, take more of the offensive position. And so I don't know if you would think that would be helpful or not, but
thank you, Judge. We certainly have had that conversation with Mr. Ruggieri, and it's definitely consideration of the board.
Yeah, I mean, look, I don't think that I don't think that anything that I say is going to get anywhere as far as demand, but absolutely, I do think it would be at least helpful to make sure that they understand our position. And with to me authority, I think that we would initiate negotiations with an opening demand of say 100,000. Tamika.
Yes. There,
We don't even
Judge. Let me add, Judge, that we have testimony from different neighbors in the community that they will testify that their goal is to bankrupt the HOA and to eradicate the deed restrictions in the HOA. That is their goal. They have written that on social media. We have documentation, and we have people in the community, and that's why I say a jury of our peers is going to be the best suited platform for us to be able to facilitate a closure to this.
Yeah. Okay. Well, I think I'd like to go back to the other side, get whatever they think, where they wanted to start, to answer the question that I asked them, and that is, where would they like to start, either with monetary or non-monetary? I don't think, and it may just be something that, obviously your answer is going to be no, but I don't want to have them consider that you're not here in good faith, and but that part of that is the strength of your own case. I don't think that if one side says, well, we'll take 100,000, if the other side comes back and says, no, we're not going to pay you 100,000, we have as strong a case as you do, and we're not going to negotiate with you where you come out on top in this, because I don't think you should take a defensive position. There is no lawsuit, and even in a lawsuit, the plaintiff in the case, is the one that files the lawsuit first, if that's what happens here. But then you have just as much right, and it sounds like just as good a grounds to sue them back, and as a counterclaimant. The only advantage, and again, I think because some of what I'm seeing here is so powerful in terms of showing them for what they've done. I don't want to say for who they are, but for showing their actions for what they've done. That I think that that would be something that's very strong evidence that you have. I'm glad you have these signs, and that would be evidence that could be used as evidence in the case. So let me go back to the other side, get their position, their opening position, and then I want to make clear to them, and I will, and I have, but again, the strength of your own case, of your own claims against them, and to talk to them a little bit, with your permission, about what I've seen here, that there are. And they know what these things are. Their lawyer might not, but they know what these signs are, what their websites say, what their misrepresentations have been, and I don't have to. I can do that in an objective fashion without saying that I can't say who wins and loses these cases, right. But you don't have
this. This is only a tip of the iceberg. We have dozens and dozens and dozens of different messages on signs that are just.
Okay. Well, let me do that. Okay, to make that.
Thank you, sir.
All right.
Thanks, Josh.
Okay.
All right, Tamika, I'm going to take a little restroom break.
I'm with you, Frank.